Thank you. Thank you, Roger. If you don't have one of these little handouts, you might want to pull one. I'm going to go through the slides, but I'm going to say a lot of things, and if you want to take a few notes along the way, you might carry back more information than just the slides themselves give you. So highly encourage you to pick up one of these in the back of the room. Well, thanks to the Rocky Mountain Inventors Association and Roger Jackson for inviting me. For those of you who haven't heard me talk before, I have a really soft spot in my heart for the Rocky Mountain Inventors Association and its predecessor, the Rocky Mountain Inventors Congress. I gave a talk back in 1984 to the annual meeting of the Rocky Mountain Inventors Congress, which had a full day of seminars for inventors and small business people starting their companies up. And I actually got the best client I've ever had in my whole life out of that little operation. My name is John Eckstein. I'm a lawyer. When I did that first talk, I was with a law firm. I've been with several law firms. I was a solo practitioner. Then I had my own little firm, and I've certainly signed the front of enough checks to understand the pain, sort of understand you have to pay your people before you pay yourself, and that can get hard sometimes. Right now I'm with the law firm of Fairfield & Woods. Fairfield & Woods is an 82-year-old law firm. We have 45 lawyers. We don't do patents. We do what we call IP light. So we recognize trade secrets. We do some copyright, a lot of trade name and trademark work. We have a number of microbreweries and brew pubs, and in fact, Super Lawyer Magazine is going to have an article interviewing me about what we do with breweries and brew pubs whenever that annual magazine comes out this year. So the question is crowdfunding, and I want you to know that this is the first time I've given this talk, and so I had to do some research because it's an evolving area. Crowdsourcing is more of the general area, which basically is raising money using the internet and the logic of crowds, many people giving $1 as opposed to one guy giving $1 million. Okay. So this is equity, selling ownership in a business in order to raise capital to develop the business. And now we'll see if I can get all the pieces to work on this here. Hard to read, but these are just the basic principles, and if you've got that handout, you can read along with me. Just so you understand, and here's the definition of security. Okay. So let's take a security is any note, promissory note, stock, treasury stock, bond, debenture, evidence of indebtedness, certificate of interest or participation in any profit agreement, pre-organization certificate subscription, transferable share, investment contract, CD for a security, passive interest in oil and gas, we talked about that, LLC interests, limited partnership interests. Those are securities. And since 1933, there's been a comprehensive scheme in the United States that regulates the offering and sale of securities and the people who are involved. Basic rule, this is how I get the big bucks. every offering, every security needs to be registered, every offering needs to be registered, every buyer and seller needs to be registered, unless they're exempt. And there are many exemptions. Okay. So the use of a securities lawyer, first and foremost, find me the exemptions so I don't have to register my securities offering at the federal level and wherever the people I want to invest in my company reside. So I was told to reemphasize that Kickstarter and Indiegogo do not permit securities to be offered on their sites. That's crowdsourcing, that's discounts, that's products, but that's not securities. Circle Up, on the other hand, is a broker-dealer and registered with the SEC under the 1934 Act as a broker-dealer. There are lots of websites out there. If you're going to be dealing with a website, you've got to understand whether it's regulated, and if so, how it's regulated, if you're going to sell securities on the internet. Okay. So, I've spoken to this group twice before in the not too distant past. Some of these slides you'll see, but I gave a talk to this group a few years ago about the Jobs Act, Jumpstart Our Business Startups Act, which was signed by the President of the United States on April 5th. There were 7 titles. There are 7 titles. I'm going to talk about 2 of those titles tonight. I'm going to talk about access to capital for job creators, which is Section 506C of the Rule 506. It's Rule 506, which was promulgated by the SEC. But what you really came for is crowdfunding, which is Title III. But what I'm going to do tonight is give you a broad overview of federal crowdfunding, state crowdfunding in Colorado, and also general advertising, general solicitation on the internet for private placements under 506C. Because these are the choices. Some people call 506C crowdfunding. It's using the internet, it's using social media, it's using general advertising. So from your point of view, it could be crowdfunding because you're going to be in the same place as an issuer. I'm approaching this from the point of view of issuers, not intermediaries or broker-dealers or anything, but people are trying to raise money. Okay. So just talking first of all, and this is, for those of you who heard me before, this is just a repeat, but so Title II of the Jobs Act took an existing safe harbor SEC rule, 506, and created a new additional exemption, which I'm mishing things together, but the new rule is 506C. Okay. So before the Jobs Act and after the Jobs Act, the old 506, now called 506B, still exists. And you could always still do that. That's a safe harbor. But you can't do general solicitation or general advertising with the old 506B. Now with the new 506C, you can do general advertising and general solicitation if you're making sales to accredited investors only and issuers take steps to verify their accredited status. The useful thing, and we'll come back to this, is that Rule 506 preempts the states. Remember when I said that you have to be registered or exempt at the federal level and the state level? Many federal exemptions do not preempt the states, so you've got to find a separate exemption at the state level, each state, in addition to the federal one. But preemption means that if you have the federal exemption, The states can't run you around to make you find a separate exemption. Automatically you're exempted at the state level for the offering. Now you're never forgiven for lying, cheating, and stealing and fraud. Okay, we don't, another reason to have a securities lawyer around is to get some advice on what's material and what should be told to investors, as opposed to just winging it and forgetting to say something, okay? It'll protect you from some criminal liability in this world if you do say, hey, lawyer, you think I got to tell people that? The lawyer would probably say yes most of the time, but every now and then they'll say, no, you don't have to, and that's helpful, okay? So 506B and C preempt the states. If you sell only to accredited investors, you can do general advertising. And the more of the same, your 506C has, remember I said people who are buying and selling securities have to be registered unless they're exempt? A broker-dealer fits in that category. There are broker-dealers that need to be registered under the Securities Exchange Act of 1934. And 506C says that if you do certain things, you will not be a broker. So you don't have to register if you're an intermediary who does those things. And in this case, it's the guy who runs the platform that you're advertising on the internet, okay? You don't have to be a registered broker-dealer if you have a 506C platform, okay? Or if you co-invest, or if you provide ancillary services. We can get into that. I mean, you can make yourself into a broker-dealer by doing extra stuff, but just running the website where they advertise their deals, that doesn't make you a broker-dealer. That's what they're saying. Yeah, we'll get around to that, but yeah. That's why I said you got to know what kind of website you're dealing with. If you go to Angel List, that's a financial advisor. If you go to, there's another one, Funders Club, that's a broker-dealer. I mean, there's different kinds of regulation for those websites. Some websites just collect the names of all the rich people, accredited investors they can find, then they go out and sell those things. But that doesn't do you any good if they're not matching them up and you don't want to pay for the list, okay? So there's a lot of websites out there. Anyway, maybe I'm pounding it in, but here we go again. I'm just saying that if you use 506C, it's only for accredited investors. Does everybody know what an accredited investor is? Generally speaking, it's a millionaire, not counting the house, or an individual who has made $200,000 a year for each of the last 2 years, or with their spouse $300,000 and expects to make it this year, or different kinds of institutions. Now the SEC put out a report, they're going to raise those numbers, okay? Also, they're going to, I don't know if they should do this, but they're going to say certain people can be classified as accredited by what they do. So they're going to put lawyers, they're going to put accountants in there. I can tell you there are an awful lot of lawyers and accountants who don't have a clue, because this is all based on the belief that money gives you access to information. The people with more money have more access to information. It's all the philosophy. 506B comes from a private placement case long ago called the Ralston-Purina case. And Ralston-Purina, the only U.S. Supreme Court case ever to interpret private offerings in the United States. And they said it's access to information. Money means you have power to get information. But they haven't changed the accredited investor definition. So they're going to raise the dollars in the definition for individuals, and they're going to spread out who knows or should. I mean, an individual who works for a broker-dealer supposedly is going to be in this list. We'll see.
Can I ask a crazy question on that?
Okay.
The new 506C, so you're allowed to do general solicitation?
Yep.
So my solicitation is like a big net. I'm going to be technically offering to non-accredited that if they get serious, then I have to take steps to verify.
Yeah, absolutely. And there's some safe harbor type steps, and then there are some, but it's all facts and circumstances. I mean, one of the things would be, for example, if you look at the assets, like this guy's worth $1 million, okay? If you can, one of the safe harbors is if you can get his accountant to write you a letter to say he's worth $1 million. That's a safe harbor. You can, but you've got to have a system to verify. And even if he's accredited, but you don't have the system, you lose the exemption. You got to have a system, okay? So it's like Google him. I mean, it's not that much of a system, but you got to have a system to verify. This is all history, I'm telling you. This is all, I've told you this guy's stuff before, but people forget that you got to have a system. If the system doesn't, so the SEC can say your system doesn't work, I guess. Anyway, we're going to get there. Finally there. Okay. This was in the Jobs Act, equity crowdfunding. I don't know if you can read this or not. Oh, by the way, there are 10 million accredited people in the individuals in the United States right now. I thought that was a useful statistic. 10 million, 3 to 7% of U.S. citizens. I don't know, that's another thing. The SEC said this. The SEC also was telling everybody 2/3 of all startups fail in the first 3 years. So thanks a lot, SEC. Anyway, okay. So this was in the statute. I'm doing the statute first, because the statute was not self-actualizing. There had to be rules, SEC rules, and I'm going to tell you there are some differences between the SEC rules that came out finally, that are effective on May 16th, and the statute itself. So here you can see, I even got a pointer. So there's a new exemption from registration for equity crowdfunding. This is section 4A6. 4A6. You see 4A6? That means equity crowdfunding. Okay. So it's a method where small aggregate amounts of securities of an issuer is sold through brokers or funding portals or platforms to investors in small individual amounts. There's no number of investors maximum for crowdfunding. Okay. The statute had some restrictions. The aggregate amount sold by an issuer, when added to the amount of securities previously sold by the issuer in reliance on the exemption, can't exceed $1 million in the previous 12 months. But I'm going to tell you, the regulations are slightly different than that. Then the statute said the aggregate amount sold in the previous 12 months to an individual investor by an issuer is limited to 2,000 or 5% of the annual income or net worth, and that is whichever is greater, assuming the annual income or net worth of the investor is less than 100,000, or if it's more than 100,000, it's 10% of the lower of, and I didn't put lower in there, but I should have, 10% of the lower of the annual amount or net worth of the investor, not to exceed a maximum aggregate amount sold of 100,000. Okay? The transaction must be conducted through a broker or a funding portal. It's not available to foreign issuers, although there's a way around that. Okay. Issuers and intermediaries must do a number of other things. The statute goes on for 6 pages. That's a pretty damn long exemption in the statute, where the one for the one that 506 is based on says offerings not involving a public offering. That's the private placement. Here we're talking about 6 pages. But the useful thing to remember, 4A6 preempts state regulations for the offering. Okay. So there are preemptions, so you can do 2 different kinds of offerings at the same time, but the states can't stop your crowdfunding. That's the basic.
But these are non-accredited people.
Non-accredited. Yeah, there's the big difference is supposedly this is for a lot of people who've never had a, quote, an opportunity, close quote, to invest in a company before. Like your maid, your cleaning lady. Okay, I'm just saying, you have to be careful here because just because it's easy doesn't make it right.
If I'm not accredited and I went out to buy like regular stock on the market,
Yeah.
say GM, right?
Sure, you could do that.
Is there any limit to how much I can buy?
Nope.
I could sing
But
price and I have it.
sure, it depends how you buy it though. If you're going through a broker, and then the broker is supposed to make sure, this is way off topic, is supposed to make sure that they understand your investment objectives. And let's see, there's a few things, and this has to be suitable for you, okay? So if it's a widow and it's her last 5,000, that's not a suitable thing for the broker-dealer to let her invest in. Broker gets dinged for that. Now, the brokers aren't fiduciaries, but, I mean, investment advisors are fiduciaries, but the broker, if it's suitable and they understand the objectives, you know, they can sell it to you, and they do, okay?
So the theory is we're protecting the investor, but we really protect the investor more on a startup than we do.
There's a ton of protections for investors in these rules. I'm not too worried about the investors in these rules, okay?
But like if I'm an investor in a blue chip,
Pardon me?
if I'm an investor in a blue chip, I have a lower level of protection.
Well, the broker, he shouldn't let you buy. But if you want to buy it, he'll sell it to you. Right. Unless they take discretion. If they take discretion, then they're fiduciaries. But you don't want to give, excuse me, we represent a lot of broker-dealers in our firm, but you've got to have a lot of money to play with before you start giving discretion to a broker. Okay, let's just keep going here. So the rules came out. The final rules came out. They were issued, where is this button? October 30th. They're effective May 16th. Okay. So these are the rules now. This is the SEC talking, not Congress. Okay. Once again, aggregate 1 million sold, but in 12 months. But what they're saying is sold only under Section 4A6. So you could do 2 crowdfundings, as long as you hadn't raised over $1 million in either one of them. Functionally, it's $1 million a year for crowdfunding. That's functionally what they're saying there. And when I say no integration, what that means is that you can have other exemptions going at the same time you're doing your crowdfunding, as long as you comply with those individual exemptions. So remember 506B, no general advertising, no general solicitation. And here you've got crowdfunding, which is general advertising and general solicitation. So your private placement 506B people better not have gotten fired up and all excited because of your crowdfunding solicitations. You got to keep some kind of wall between, if you have 2 different offerings, 2 different types of exemptions going at the same time. Okay. Right. Once again, you see the 2,000, 5%, 100,000, 10% of the lesser of net income or net worth. So, but you've got to use the platform. Only one platform. Only one platform. Only one funding portal. Okay. And that we'll see in a second. We're going to talk about what the portal's got to do, the intermediary has to do to qualify as a portal. But you've got to have a complying intermediary. If your intermediary doesn't comply, you've blown your exemption. And you've been doing general advertising and general solicitation without an exemption. That's not good if you're selling to unaccredited investors. Okay? Also, you can't use it if you're not a U.S. entity, if you are a public reporting company, like a public traded company. A bad actor, you guys know what bad actors are? Okay, bad actors came in under the Dodd-Frank Act. It became effective the same time, September of 2013, when 506C became effective. And bad actors are going through the Regulation A+ now has prohibitions on bad actors can't use it. Both 506s, B and C, you can't be a bad actor and do it. And they're proposing that bad actor rules apply to 504, which we'll get to in a second. Basically, a bad actor is a long list of types of people who are covered by this, and a qualifying event, a long list of events that if they occur. For example, if I'm the CEO of the company that's doing the offering, and I'm convicted of mail fraud, that's a bad act. by a covered person, bad actor, can't use the exemption. Okay.
Was that mail fraud completely unrelated or something?
I think it was probably related to securities sales or something. If you've been barred by the SEC from securities or a state by securities, there's a long list of things. I was going to bring a questionnaire and I didn't. Just Google bad actor, and 506, for example, and you'll find a zillion definitions of it. But I've got questionnaires that I have to send out to all my clients now whenever they do an offering, because 99.9% of the time, 506B is what you're still doing. Everybody's still doing these non-generally advertised, because they preempt the states. You don't have to worry about all this general advertising stuff. But if you're a bad actor, you can't use it. Bad guys are getting fewer and fewer and fewer exemptions to use. Okay, you're getting squeezed into certain places. It's just like, you know, there's just no forgiveness out there. If you don't, I'll be careful on this. Okay. Other people who can't use it are prior crowdfunding offerors who didn't do the reporting. There's a bunch of reporting you did. So if you did one and you didn't do your reporting, you can't use it, crowdfunding. And then issuer includes affiliates, and affiliates are controlled by, or common control with. So the point of it is, they're gonna say, if I have one company that controls another company, I can't do a crowdfunding with this one and a crowdfunding with that one. If they combine, they go over $1 million. You get it? Okay. And other things like that. So here we're going into more detail about crowdfunding. And I didn't time this talk, so somebody should keep me honest. Okay. There's a form, I can figure it out. Form C, and there's a question and answer format. Things that have to be disclosed, and you have to give the same disclosure. You file it with the SEC, and you give it to the intermediary. The intermediary makes sure the investors all get it. It's stuff you'd expect. Price, offering, the amount you're trying to raise, description of your business, use of proceeds, information about the officers, that's supposed to be plural, directors, company structure, related party transactions, indebtedness, description of prior offerings, etc. It's all in the form. It's pretty, I looked at the form today. It's an easy form to work with. It's not as bad as some of the question and answer stuff the SEC's shoved out before. Okay. Financials. Your annual financial, you've got to give them 2 complete years of financials if they're available. Otherwise, you give them what you got. Okay. If the company's been around for 1.5 years, you give them 1.5 years worth of financials. Okay. But if you're raising 100,000 or less, the CEO just has to certify these things are true. If you're raising between 100,000 less than 500, a CPA has to review the financials. If you're raising over 500,000 and it's your first crowdfunding deal, then you can still have it reviewed. But if it's not your first crowdfunding, then you need to have it audited. And if you got audited financials, you got to give it to them. You can't not give it to them. Okay. There's also continuing disclosure. Let's see what I got here on that. All your material changes, there's a form for that, C-A. Program updates, that's the form C-U, okay. When you hit 50% of your target, when you hit 100%. I mean, there's a lot of articles out there about this, so I'm just hitting the highlights. You have to give them annual reports on form C-AR. Let's see, advertising is limited to tombstone type notices. What you do is you use flyers, so put an ad in the paper, but all you can really say is the terms and contact info for the issuer, and functionally, you know, what you're going to try to do in the offering, and then send everybody to the platform. You're directing all the attention to that platform of the intermediary. Okay. That's what you're trying to do with your tombstone. Tombstones, you might see these little square things in the newspaper sometimes. That's what I'm talking about for a tombstone.
You're not on the phone calling anybody, soliciting, because that would be completely
That
separate.
would be like
Well,
interactive in person.
you could probably send them an email, but it would just be this tombstone stuff, saying you gotta go look at the site. You can't directly send them the disclosure documents. They've gotta go through the intermediary because, you're gonna see this in a second, the intermediary's gotta control the deal, see? Here's the stuff on intermediaries. You've gotta be a broker, if you're an intermediary, you gotta be a broker-dealer or a funding portal, and there's rules about funding portals. I'm not giving them all to you, how you set up your portal. And you've gotta belong to FINRA, the old NASD, okay? In this month, they came out with the rules for funding portals joining the FINRA. Okay? The funding portal cannot have an interest in the issuer, but, and this is a change from the statute to the rules, you can pay them off in stock in your company, which is that's a good one. The SEC helped us on that one. Okay. Platform has to basically be on the internet, okay, so they can regulate it. Okay. The intermediary has to have a reasonable basis to believe there's no fraud and no bad actors, and that the issuer can keep records. Otherwise, he denies the portal denies access to the company. And all the information they get from the company has to be made available to the investors, and the intermediary has to conclude that the investors have a reasonable basis, to conclude that the investors are qualified, and that means the investors have to complete questionnaires that go to the intermediary, and the intermediary has to maintain the funds and transmit the funds. There's a lot of little rules on this stuff. There's no safe harbors for the intermediary. It's all facts and circumstances, reasonable basis. The intermediary and the issuer are in the same boat. They can both get sued for fraud. Okay, sorry. Yeah.
So the portal, is it certified? I mean, if I'm an issuer, how do I know that they're a good portal?
You can check with the SEC.
Okay, so the SEC has,
Well, they're just going to say go to FINRA. But FINRA, everybody has to be signed up with FINRA, and FINRA will have a list. Okay. I haven't been to the FINRA list. But, you won't really know how this works until a couple hundred of these have gone through, after May 16th, they've gone through the system. I would not want to be one of the first ones going through, because you don't know how much, nobody can tell you how much it's going to cost to get it.
It's going to make everything the same, what do you call it? Like where you issue stock in your LLC.
I'm sorry.
Isn't there a way with, when you have an LLC, you can like issue stock?
It's like membership interest. It looks like stock, but it's really a partnership interest. Yeah. That's a security. It's a security. You gotta, if you're doing crowdfunding, all this applies to it. Okay. Yep. Yep. Remember my definition of security. Okay.
public, their members are just partners with them.
Okay, let me see if but the whole point is, the intermediary's watching the issuer, and the issuer's watching the intermediary. And they both have to make sure that the investors know what the hell's going on. It's sort of a self-policing kind of thing. Still don't know what I'm doing here. So the investor has to represent that the investors got all the materials, and they understand they could lose all their money, and they've got a 48-hour cancellation period. The offering has to be open for at least 21 days. Okay. There's a lot of little bitty rules on that. The offered securities are restricted. It means they can't be resold for 12 months. Okay. There's a lot of rules about restricted securities that apply in other places. But you can resell them to an accredited investor, and there's a lot of little games that people could play, like get 1,000 people to buy them, but then they all sell them to me because there's a lot of little ways you can structure this if you're, you can manipulate the system if you've got a lot of money, but why would they, is my point. Okay, I want to switch gears from the federal one, and there's trust me, there's like 12 or 15 pages of the summaries. This is a 700-page release by the SEC, and I have not read the release. I read the rules at the end of it, and I must have read about 30 write-ups about it. But all the reasons why the SEC did or didn't do this, that, or the other that's in front of the rules, I just couldn't do it. It's just because this is complicated, okay? This is not simple. And you'll see at the end, I'm not a fan, okay? I'm not a fan for the clients, the guys who want to raise money. This is not the way to use the internet the way it's best able to be used, okay? So let's go on. Crowdfunding under Colorado law. So the feds took a long time. April 5th, 2012, and it's not even effective yet. So the feds took a long time to get their regulation crowdfunding out. So a number of the states, Colorado wasn't in the first 15, but it was in the second 15 to come out with some other rules, okay? So the Colorado rules, and these are in effect now, okay? What about using Colorado crowdfunding instead? Just use Colorado crowdfunding. So it relies on section 3A11, which is a federal exemption that says if you do an intra-state, an offering only inside your state, then that's an exemption from the federal stuff, okay? So there is this 3A11, and there was a safe harbor. I'm calling it old. You'll see in a second there's some changes coming. But Rule 147 was an SEC safe harbor. If you follow these, do these things, then you will be under 3A11. You don't have to worry about it. And so they passed, last session of the legislature, they passed a crowdfunding statute, and then they enacted a bunch of rules. So the state crowdfunding rules were effective October 15, 2015. So they're in force. Okay. So just a little bit about the state crowdfunding rules. Issuers must be organized under Colorado law. A Colorado entity, not a Delaware entity, Colorado entity. With 80% of the assets located in Colorado and 80% of the proceeds used in Colorado. There's a maximum of $1 million can be raised with unaudited financials, but you can raise $2 million with audited financials. That's bigger than the federal one. Okay. Yes?
I'm wondering about the dollar amount. I mean, $1 million doesn't go very far anymore. And
Right.
depending on the type of startup or crowdfunding that they're doing, that might not be enough to even get them, you know.
You got it. That's one of the major complaints. But this is still better than the feds. Okay. But we'll get around to how I think you might want to be able to use this stuff. But at least before the federal crowdfunding came out, even though it was in the statute, we knew it was limited to $1 million and $100,000 per person, you know, in annually in crowdfunding. There's a lot of regulation stuff I didn't tell you at the federal level. There are disclosures, required disclosures in Form CF2, and I brought the form. I printed it off this afternoon. I don't like their form. Okay, they have all this big, all caps stuff that the feds don't have all this magic language. Once you wade past, there's a lot of boilerplate, big fat things in here. These rules were written, I got two sets. I can pass one around. This is the state one. Just so you can see what the disclosure is like from the state. It was written by state regulators. Let me just explain. The Securities Commissioner in Colorado is a guy called Jerry Rome. This is off the record. Okay, Jerry's a great guy, but he never saw a deal that wasn't a scam. He's an enforcer. He's a regulator. He's a litigator. He didn't come out of small business. He's a lawyer. He's been doing this for 36 years. He doesn't trust anybody. He just doesn't trust anybody. I was on the board of advisors, 3 securities commissioners. Jerry Rome doesn't trust me. There's something in it for me. And I'm saying, but you know, just trying to get the laws right. So anyway, he's got lots of disclosure in there. Okay, but that's fine. But the companies, small business isn't, I'm on the board of the Denver Boulder Better Business Bureau. There are a lot of great businesses out there. Guys aren't trying to rip everybody off all the time. The prior securities commissioner was Fred Joseph. He wasn't a lawyer, he came out of industry. And he'd get the bad guys, but let the good guys go. And Phil Fagan was before him, and Royce Griffin was before that. So we've got a securities commissioner who doesn't trust small business, okay? We've got an SEC in their disclosures that doesn't understand small business. So between them, we're not being helped by the regulators. In any event, they require disclosures. Investors must be Colorado residents, not investing over $5,000 unless accredited. Well, that's a whole lot of people, okay, investing to get to your 1 million or 2 million, okay? That's a lot of bodies. Now, here we call them online intermediaries or OLIs. They're not, don't call them platforms. But in any event, there are specific rules in Colorado also for the OLIs. There are at least 5 OLIs that have filed Form CF3, which is how you sign up as a portal in Colorado to use this. And I went to some of their sites, okay? Of the 5 who've signed up, 3 of those aren't functional right now, okay? But there's at least one that is, okay? And I think, if you guys know Carl Dakin, I think he owns that site. Anyway, he's a bright guy. There's a group called Crowdfunding Colorado or something that meets all the time. And he's trying to create some liquidity and opportunity. I don't know if he's gonna make any money, but at least he set up a site. So there is an online intermediary, and these rules are enforced. The problem is the rules require that there be an escrow agent. Now, to hold the $1 million or $2 million, it has to be a bank, savings and loan, or credit union. And they have to escrow at least half the aggregate offering amount. So if you want to raise $100,000, they escrow $50,000. Plus, what bank is going to screw with something that small? Why should they take the risk? Well, they can't get their fees out of it. But there is a bill going through the legislature. Let's see, proposed change in the legislature now, and I'm just ranting. The Representative Pete Lee is carrying this bill, and I encourage you to write to Representative Pete Lee and tell him what you'd like to see and changes for the crowdfunding in Colorado. I said they should expand the pool of escrow agents. They're expanding it to cover depository institutions, but that's not adding much. I said they should take anybody who is licensed by the state, like lawyers, like accounting firms, real estate agents, anybody who could lose their license and their livelihood if they screw it up, and let them hold the money too. I mean, just get, we would never be our firm doesn't play in this game, but there are plenty of really good lawyers who are solos or in small firms who, if they had a client for 10 or 15 years, would do it, okay? I mean, I know there are, but not the way this is set up, okay? Anyway, there are data collection and reporting obligations. There, bad actors are prohibited, the same definition as the feds. And here you've got to have strict compliance. One mistake, you lose the exemption. Now the feds have an insignificant deviations thing, so the feds let you be a little looser on, you can make a mistake and you won't get killed. But here you lose your exemption. Remember, you've been doing general advertising, so now you got general advertising, you lost your exemption, poof, you're doing a public offering without having registered, poof, there are criminal penalties for that. I mean, it's just not helpful. So John, what are we gonna do? Oh, there's some more rules proposed. This is interesting. This is mostly for me. But the SEC, when they put out with the final crowdfunding rules, they also came up with proposed changes to Rule 504 and Rule 147. Let's do Rule 147 first. Remember, I said that Rule 147 was the safe harbor that the SEC promulgated a long time ago under Section 3A11, the intrastate offering. So if you did what's in old Rule 147, you were intrastate, and you come to Colorado and do your Colorado crowdfunding. That was okay. By the way, Section 3A11 and Rule 147 are written into the Colorado statute, okay? They're written into the statute. And so this says that you've got to comply with federal 3A11 and Rule 147 to use Colorado crowdfunding. But now the SEC is proposing changes to Rule 147, okay? So, they're going to allow offers outside the state under the new Rule 147, okay? What that does is the old Rule 147 didn't allow offers outside the state because the statute, 3A11, says you can't make offers outside the state. So what they're doing is they're creating a new 147, which is decoupled from the old 3A11, with the existing 3A11. This is a mistake. It says old Rule 147 still remains. No, 3A11 still remains. That's my mistake. That should say 3A11 right there. Because, so what's going to happen is the Colorado crowdfunding statute, if it isn't amended, once the SEC comes out with this 147, if you have to comply with 3A11 and new 147, you will violate federal law. So they're going to have to amend the statute. This is just not the way to run the railroad, okay? Now, the guys who helped the state put their law together last year told Jerry Rome. They told him not to put that in there. Just put, just put in 311. Don't put in. I'm trying to make this simple. This is not simple. This is confusing. Okay, it can't be made simple. In any event, just so you know, they're going to increase the number. I'll go to 5 million. There were no limits on 147 before. But here you see it, I say it, if you have the new 147, it won't comply with 3A11. So they're going to have to change the state statute, state regs. And also 504, just so you know, 504 was an exemption. There's no preemption there, but it was limited to $1 million. Now you can go up to 5 million. At least they're going to make that change. And the bad actor thing is coming in. So as long as you're not a bad actor, 504 has become a more valuable thing. And you can do general advertising in a 504 if you have a state exemption to do it with. So there's more to come. The answer is we don't have the answer yet on crowdfunding. You're going to see that. Okay. So what do we do with this federal thing that's sort of screwed up, the state thing that's sort of screwed up? Right now, we are still stuck with 506B and C. Okay. In my humble opinion, the federal one is lots of complications, time and cost to raise relatively small amounts of money. The Colorado one is fewer complexities to raise more money, but you can't find an escrow agent. Everything's got to be escrowed. Okay? And you've got this problem coming down the road of Rule 147 changes, and will they have to change the rules again? Okay? So stick with if I were doing it, your 506C, sell to accredited investors only, you can do general advertising. Or your 506B, don't advertise. Okay. I mean, that's almost, I've read like 40 of these law firm things. Everybody's saying the same thing. Nobody's saying that this is a wonderful world that we've just come into. Everybody is saying that it's not there yet. Traps for the unwary. Lawyers aren't going to want to hang with this thing.
You think a lot of people use it?
Nobody, well, the theory of crowdfunding from my point of view, remember what I said, is a BBB, A+ rated restaurant, multi-generational family, ought to be able to go on the internet, in my humble opinion, and sell, $200,000 worth of debt to all their customers, to keep the restaurant going. That's what I think. That's the beauty of crowdfunding. It was supposed to help small business. and reach out to people who aren't rich but would like to keep the restaurant going. That's my theory of crowdfunding, okay? And we're a long way from that. The SEC doesn't understand small business at all, never has, okay? We're lucky we got 506B and C, okay? And the only reason we do is because hedge funds and venture capital funds use 506B and C so they can raise money. So Wall Street talks and, you know, but they don't have a clue about crowdfunding. I mean, the private placements exempt, these are articles on our website, okay? Let's see, let me see what else I got. Here's conversations, that's my bio. Let's do some questions and stuff if there's more. I'm sorry, this is it's just the way it is. I mean, I wanted to be a more complete talk, but we're still in the middle. Ask me a year from now, okay? And I'll have a whole lot better.
Ask a year from now.
Well, yeah. But you just keep waiting for good things. But I do think Carl Dakin's group is pushes that crowdfunding group. I don't know where they meet, but if you Google Colorado crowdfunding, it's the first thing that pops up, okay?
Are
That's me.
Colorado intermediaries, do they tend to like specialize in just the state
I'm sorry?
crowdfunding?
Say that?
Do they just do
I
the
don't
state?
know. I didn't check to see those 5 intermediaries. I didn't check.
State, or they're just, if they're doing it, they're doing state and
I don't know. The only way to really know that is either call them or see if any of those 5 are listed in the FINRA site. And there's got to be 1 or 2, okay? Now, there are plenty of broker-dealers out there. The problem, and the broker-dealers could, if it weren't for that escrow requirement, broker-dealers could be holding the money because they do hold the money in regular deals. But I don't know that a broker-dealer is allowed to hold the money in Colorado crowdfunding.
Why do you think the limits are different? I mean, there's so much stuff that you went through that's.
They want to protect the investor.
Is it to protect the investor, or is it so they don't use it as like a tax?
No, their statute says protect the investors. It is way down the list of things to enable small business to raise money. Now, the legislature said in Colorado crowdfunding statute something about their goal to here it is, hang on a second. The General Assembly hereby finds that startup companies play a critical role. This is in 2015. Startup companies a critical role in expanding economic opportunities, creating new jobs, and generating revenues. Lack of access to capital is an obstacle. Costs and complexities of state regulation can outweigh the benefits. The use of crowdfunding is restricted by our state securities laws. Crowdfunding allows small companies to access the capital, so the legislature declares, in compliance with exemptions, they are doing this to create a Colorado crowdfunding option with limitations to protect investors, and it will enable Colorado businesses to obtain capital, democratize venture capital formation, and facilitate investment by Colorado residents and Colorado startups, promoting. So that whole legislative declaration doesn't say anything about the state securities commissioner sticking all this stuff into the deal, okay? My humble opinion is Dan Pabon, Democrat, Pete Lee, Republican, they ran this bill. I went and talked about this stuff to the trade associations that were promoting it last year. I don't know a member of them, but the Colorado Technology Association, the Colorado Bioscience Association, the Colorado Clean Tech Industry Association. They have lobbyists who thought this would help small businesses raise money. And, you know, Pabon said, well, John, let's just get it enacted and then we can clean it up later. Well, this thing they're doing this year, adding a couple more, like the trust companies and things, that's not on that escrow thing. What I wanted was, what did I want? Add all those, anybody can hold the money who could lose their license and be put out of business, you know, that kind of thing. I wanted more money to be raised. I wanted, this 147 thing is a major headache. They should never have written that in the statute, get it out of there. So we don't have to change the statute every time the feds move, okay? And, basically, the problem is I don't want to say anything bad about Jerry Rome. I mean, he's a regulator. I got to run my deals over there too, okay? I mean, it's hard to come out and tell him, you're just not helping the cause here, man. So I could say it like that. I couldn't say, you have no clue what you're, random action by ill-informed power brokers is one of the most dangerous things in the world of regulation. So, anyway, sorry. But I'm optimistic. I mean, Senator Bennett pulled that crowdfunding thing through in the Jobs Act, and, the SEC turned on him. The SEC study group, small business study group, recommended all these things, and the SEC guy voted for it. And then when Bennett added it into the Jobs Act stuff, the crowdfunding stuff, the SEC came in and larded all this extra stuff on. And so Senator Bennett hasn't been able, he's pretty embarrassed by what turned out the other end, but at least he did something, okay? Sorry.
I don't see how that's gonna help anybody that starts a business to.
Well, it's not. I mean, if you do it yourself, you can't do it yourself. It's too complex. Okay? Everybody says it's sort of stillborn. Okay. No lawyer wants to work on this stuff because I can't get you where you want to go.
And for a lot of startups, they don't have a lot of resources. And to have the resources to do something like that, they would be so diluted of their time, they couldn't really do a startup.
Right, you can spend all your time doing the form and you wouldn't be able to get there. They said it's only going to take 100 hours, the SEC said, to fill out the form. And I think that's silly, knowing what I know about how companies get organized to go out and sell securities and not lie to anybody. It's hard. It's just they were dreaming. So here, the crowdfunding, federal crowdfunding was adopted 3-1 vote. The guy who voted against, and remember it was October 30th, just before Halloween. So he says, while crowdfunding was intended to be a treat for the smallest and least sophisticated companies seeking to raise capital, today's rules are full of tricks. The rules will spin a complex web of provisions and requirements for compliance. Such burdens will spook many small businesses from pursuing crowdfunding as a viable path to raising capital. And that's just what people are saying. Sorry, I wish I were bearing better news, but
Is there an escrow requirement at the federal
no.
level? There isn't.
Mm-mm.
When is the typical point in time of the startup to do their crowdfunding initiative over?
Well, if I didn't have to worry about the rules, okay.
I guess
You see what you got, family, friends, okay.
Right.
Then, my theory on this, when the rules weren't coming out, I was on some panels, I said, you don't know if it's going to win or not, but let's do some convertible debt, okay, and with some limits, so we could buy it all back in 3 years for like twice as much as they loaned us, plus interest or something. And and then just go out and generally advertise, and maybe you could raise $200,000, $300,000, okay, that kind of thing. But there's so much work to get there, that kind of thing. That's where I would see it. Or, I wouldn't do it if you'd already done a private placement under 506B, no general advertising. Then you could do a crowdfunding, and your selling documents would look a lot better because you just raised some other money, see? So you could plunk that in there and say, and then you put in these rules because this is all pre-VC. This is all before the big money, okay? But you could mix and match these exemptions and move it along, But the problem with the federal one is it's so low, okay? So I think it's possible to do them, excuse me, I didn't mean to point, but it's possible. The exemption in and of itself doesn't get you very far. But if you've got another exemption, another way to access to capital, okay, besides the crowdfunding, maybe you could find a way to remember it's not all integrated, it's not all jammed together. If you do the federal crowdfunding offering, that doesn't get pushed in together with the other exemption, 506B, as long as you don't find the investors one way or the other, okay? So you could probably work it, but you need to talk to a lawyer to figure that part out. It's too complicated to figure out on your own. Excuse me, I just think it is, okay? And some people might know it if you've done a lot of deals as a principal, but you want to have a lawyer. I mean, somebody you can blame if it doesn't work. but I think you could crowdfunding. You saw who can't use it, okay? So I think it exists. It's supposed to be there early in the life of the company, okay, or early in the life of even an invention. I mean, you could probably get, if you had an entity, you could borrow money to you just got to find the investors. But once again, it can't be through crowdfunding. It's just too expensive to get there, too complicated. You take on all this risk just to raise a little bit of money, you know.
But if I was to do it, I mean, it would be after my first angel round, or?
Well, you could, if you did a 506B as your angel round, say, 506B is your angel round. So you say, okay, now we're going to go out. It's the same type of thinking, 506B versus 506C, okay? If I tell people this sometimes, let's try the private placement first without general advertising, 506B. Say we need to raise $1 million, okay? So we raise $600,000 with that. Okay, now let's convert the B into a C. Problem is there is integration, they get pushed together. So you make one offering out of the, you turn your 506B into a 506C, now you do general advertising, and you bring in more investors. But you can't have brought in any unaccrediteds in your 506B because that blows out your 506C. See how the lawyer moves the different exemptions around and tries to scheme it out? That's a lot of securities lawyers, like that 147 thing that I talked about, where the old 147 is going away, the new 147 won't work under 3A11, it won't work in the Colorado statute. That's pretty subtle. A lot of lawyers don't know that don't understand, because the new 147 isn't coming out of 3A11, it's coming from another place, it's coming from the SEC's ability to create its own exemptions. So that's pretty sophisticated. I mean, I didn't know that stuff for 20 years, what I'm talking about right now. It gets complicated, so, sorry. But there's another, there are other exemptions, not exemptions, but there are other ways to raise money with general advertising. You could do a registered deal in Colorado. I'm just coming off the top now. There's a form called Form RF, okay, the state has. It's a registered offering. It's tried and true. Not that many people have used it. But you got to file a registration statement. You got to go through the whole rigmarole. Most lawyers don't like registering securities, not doing the exemption, but doing a registration, because it's a criminal penalties for filing a false statement with the state or the feds. So you try to do non-registered because it doesn't get you to the highest risk of making a mistake. But you can properly advised, you could raise $2, $3, $4 million, particularly with this 504 offering that's coming down the pike. That's what it would be, exempt at the federal level under a 504, but registered at the state of Colorado, Wyoming, Nebraska, Kansas, Arizona, and raise some money that way. But your company needs to probably have done some other fundings first to be able to take on that kind of risk. Crowdfunding just isn't here yet. I mean, it's just not here yet.
But I mean, when it is, shouldn't it be a viable alternative to venture capitalists? Like you can go angel to crowdfunding.
Yeah.
Skip
Yeah.
venture capitalists.
Yeah, it should be. But also it should be for the grocery stores. In my humble way I wrote in that letter there, I said, it doesn't matter who you are, whether you're a neighborhood grocery store or a company that's got the highest tech super duper thing with a great management team, venture capital fundable, you should be able to do either one, okay? I mean, the rules should apply to everybody equally in crowdfunding, okay? And neither one of these crowdfunding, state or federal, gets there for you, okay?
I keep seeing a commercial on TV that, they say, bring any business public, even startups. Has that got something to do with these rules?
I don't know.
I should have written that down.
There's no definition of public offering in the federal securities laws. And so is this, either it has to be registered under Section 5 or it doesn't, okay? So you got to be careful what you're dealing with there. General advertising, general solicitation is being looked at much more carefully than it used to be. Before, the distinction got to be really important between 506B and 506C. Things that they used to be able to do in these demo days and these Rockies Venture Club angel-type meetings and stuff, where things that before the Jobs Act and this 506, Title II, 506B and C stuff, they did a lot more things and nobody paid attention. The regulators didn't pay. Now, all those groups have had to tighten up because they used to generally advertise, come to our meeting, we're gonna hear about these 5 companies, this, that, or the other. Now they gotta worry about whether that's general advertising. It's not the Rockies Venture Club's problem, it's each of the individual companies presenting's problem, okay? It's very interesting. But so I don't know what you're talking about. It'd be nice to know because I like to keep an eye on some.
Watching the businesses, commercial comes across and says, bring your company, public, startups, everything,
It could be a broker-dealer looking for deals. That makes sense. That makes sense. There are a lot fewer. Yeah. Or send it to me. I mean, I'd be happy to look. I'll tell you what it is if I can figure it out. Well, just find it for me. Have I been too flip about this? I mean, I wasn't as detail, factual oriented. I just didn't want people to get too excited. Well, the federal isn't effective yet. Still a crime until May 16th. Not at the federal level. Now, the 506C, general advertising, general solicitation for accredited investors only, that has not taken off because of this general advertising, because of a number of things that are in it. People are still doing the 506B, private placements, no general advertising. But, you know, you can sell securities on the internet if you have a password. You can go to a password-protected website and buy a 506B offering. It's just the general advertising to get people to come to that site. You can't do that with a 506B.
And this, if your investors that do it, if you say you go belly up, can they write that off?
That's a tax question. I'm not a tax lawyer anymore, used to be. But sure, I mean, it's like everything else. It's a capital investment. Long-term capital gain, long-term capital loss, short-term capital.
It has to be offset by gain somewhere.
Up to 3,000.
You can't do a net negative.
You know, you do $3,000. I mean, I can't remember.
Maybe this is confusing, we all stay through, try to figure it all out.
If you lose more money than you make, then
It carries over, but it carries over. Carries
you're
over.
stupid.
Hey, I've lost plenty of money on microbreweries. That's where I lost my money. Just because they could brew beer doesn't mean they knew how to manage their way out of a paper bag. So. Okay, that's it, I guess. Thanks for coming. Appreciate it.